Module 1, Company Formation Conversion. So the introduction part, incorporation of private company or public companies, company limited by guarantee and unlimited companies, or its conversion or reconversion or re-registration. ఈ ప్రొసీజర్స్ అన్నింటి గురించి ఎక్స్ప్లెనేషన్ కంపెనీస్ యాక్ట్ 2013 సిఎంఏ ఫైనల్ పేపర్ నెంబర్ 13 ఒకసారి చూద్దాం. కంపెనీస్ యాక్ట్ 1913 was the first structure of law on company formation of organization. ఫస్ట్ బ్రిటిషర్స్ ఉన్నప్పుడు చార్టర్స్ యాక్ట్స్ అనేది ఉండే, చార్టర్ యాక్ట్స్ అని, స్టాట్యుటరీ యాక్ట్స్ అని. ఈ చార్టర్ యాక్ట్స్ అనేది ఈస్ట్ ఇండియా కంపెనీ వచ్చినప్పుడు ఈస్ట్ ఇండియా కంపెనీ ఫార్మేషన్లో రూల్స్ అండ్ రెగ్యులేషన్స్ని ఫ్రేమ్ చేసి ఒక చార్టర్ అనేది ప్రిపేర్ చేశారు. కొన్ని రోజుల తర్వాత ఆ కంపెనీస్ అన్నింటినీ ఆ చార్టర్ కింద క్రియేట్ అవుతూ వచ్చాయి, ఇన్కార్పొరేట్ చేస్తూ వచ్చారు కాబట్టి వాటిని చార్టర్ కంపెనీస్ అని అన్నారు. ఆఫ్టర్ దట్ కంపెనీస్ యాక్ట్ 1913 ఇవన్నీ స్టాట్యుటరీ యాక్ట్స్. కంపెనీస్ యాక్ట్ 1913 was the first structured law on company formation of organization. Some of the concepts of 1913 Act are still present in 2013 Act. This Act continued till 1956, Companies Act 1956. When the first Companies Act of Independent India was passed in 1956, after independence 1947, first Companies Act was passed in 1956. Before independence, first Companies Act వచ్చేసి 1913. After independence 1956. And this act has regulated the most eventful years of growth and stabilization of corporate India. Government made many attempts to introduce new Companies Act and various committees were set up. Replacing an act of such large magnitude was not a small task. And many factors and many facets were to be seen, and after 757 years the new companies were drafted and passed in 2013 to cope up with the existing technology developments. The Companies Act 2013 consisting 29 chapters, 470 sections, 7 schedules, 29 chapters, 470 sections, 7 schedules as against 658 sections. ఎప్పుడు పాత 1956 Companies Actలో 658 sections under 13 parts, 15 schedules ఉండే. 15 schedules, 13 parts, 658 sections నుంచి 29 chapters, 470 sections and 7 schedules వీటిని ఫ్రేమ్ చేశారు. అంటే అవసరం లేని ప్రొవిజన్స్ అన్నింటినీ తీసేశారు. అండ్ వాజ్ నోటిఫైడ్ పార్షియల్లీ ఆన్ 12 September 2013. 12 September 2013 ఒక 55 సెక్షన్స్ని ఇంట్రడ్యూస్ చేశారు. దిస్ ఇస్ ఒక ఇన్స్టాల్మెంట్ వైజ్ ఇంట్రడ్యూస్ నోటిఫికేషన్స్ ఇచ్చుకుంటూ వచ్చారంటే కంపెనీస్ యాక్ట్ ప్రొవిజన్స్ అన్నింటినీ. వాజ్ నోటిఫైడ్ పార్షియల్ ఇన్ 2013 September 12th అంటే ఇదే మంత్ అన్నట్టు 55 సెక్షన్స్. అండ్ ఆఫ్టర్ పార్షియల్లీ అగైన్స్ 26 March 2014. నెక్స్ట్ ఇయర్ March 26, 2014లో 168 సెక్షన్స్ని ఇంట్రడ్యూస్ చేశారు విత్ ఎఫెక్ట్ ఫ్రమ్ 1st April 2014. 1st April 2014 నుంచి అప్లికబుల్ అవుతాయి. 26th March 2014 168 సెక్షన్స్ ఇచ్చారు. 55 సెక్షన్స్ 12th September ఇచ్చారు. అండ్ పార్ట్ ఆఫ్ ద ప్రొవిజన్స్ రిలేటింగ్ టు నేషనల్ కంపెనీ లా ట్రిబ్యునల్కి సంబంధించిన సెక్షన్స్ అన్నీ they were effectively notified from 1st June 2016. 1st June 2016 నుంచి ఫుల్ ఫ్లెడ్జ్డ్గా ద యాక్ట్ వాజ్ ఇంప్లిమెంటింగ్. 168 సెక్షన్స్ 26th March అండ్ 55 సెక్షన్స్ 12 September 2013. ఎన్సిఎల్టీకి సంబంధించిన ప్రొవిజన్స్ 1st June 2016 నుంచి. అండ్ కంపెనీస్ యాక్ట్ 2013. Hereafter the act consolidates and amends the law relating to companies in India and replaces the Companies Act 1956 in phases, which is 56 years old. The new act intends to improve corporate governance and to further strengthen the regulations for corporate sectors with introduction of key provisions as duties and liabilities of directors, independent directors, auditor rotation, establishment of serious fraud investigation office, construction of National Financial Reporting Authority NAFRA, and class action suit corporate social responsibility. To strengthen these provisions, these amendments, these activities, Companies Act 2013 was framed. The new act was intended to improve corporate governance and to further strengthen the regulations. To strengthen the regulation, they were incorporated in corporate sector with the introduction of key provisions as duties and liabilities of directors, independent directors, auditor rotations, establishment of serious fraud investigation offices, SFIOs, constitution of NAFRA, National Financial Reporting Authority, and class suit action, corporate social responsibility, etc. The Companies Act 2013 is administered by the central government through the Ministry of Corporate Affairs and offices of Registrar of Companies. It was managed by Ministry of Companies or Ministry of Corporate Affairs only. For registration of companies, offices of Registrar of Companies, official liquidators, public trustees, directors of inspection, National Company Law Tribunal, National Company Law Appellate Tribunal, etc. ఇవన్నిటిని మినిస్ట్రీ ఆఫ్ కార్పొరేట్ అఫైర్స్ రెగ్యులేట్ చేసుకుంటూ వస్తుంది. సో ద రిజిస్ట్రార్ ఆఫ్ కంపెనీస్ ఆర్ఓసి కంట్రోల్స్ ద టాస్క్ ఆఫ్ ఇన్కార్పొరేషన్ ఆఫ్ న్యూ కంపెనీస్ అండ్ అడ్మినిస్ట్రేషన్ అండ్ రన్నింగ్ ఆఫ్ కంపెనీస్. బ్యాక్ అండ్ ప్రాసెస్లో ఈ పబ్లిక్ ట్రస్టీస్, నేషనల్ కంపెనీ లా ట్రిబ్యునల్, నేషనల్ కంపెనీ లా అపెలేట్ ట్రిబ్యునల్, ఆఫ్టర్ దాట్ దిస్ అఫీషియల్ లిక్విడేటర్స్ వీళ్ళందరూ కూడా బ్యాక్ ఎండ్లో వర్క్ చేస్తూ ఉంటారు అన్నమాట. అడ్మినిస్ట్రేషన్, రైట్. Ministry of Corporate Affairs was primarily concerned with administration of Companies Act 2013, other allied acts and rules regulations framed thereunder, mainly for regulating the functioning of a corporate sector in accordance with law. The structural shift is that while in 1956 Act only 16% was delegated to the central government, and in 2013 the Act was delegated 74% is delegated for legislation only, right. The structural shift was changed. The totally was 74% was delegated to legislation only. This has resulted to frequent change in rules and regulations. The act was amended in May 2015 and after that 2017 and modified in January 2018, July 2019, September 2020. Relevant provisions of amendments to the extent covered under syllabus has been incorporated in this study material. And after that there are some provisions, some definitions are there. Definitions and features of company. The first, company is an artificial, legal, juristic person separate from its members, having a perpetual succession. In terms of Companies Act 2013, company means a company incorporated under the Act or under previous company law, section 2, subsection 20. A company may be incorporated company or corporate or an unincorporated company. An incorporated company is a single legal artificial person distinct from individuals constituting it, whereas an unincorporated company such as a partnership is mere collection of aggregation of individuals. Therefore, unlike a partnership firm or a company is a corporate body. A company is a corporate body and a legal person having a status and personality distinct and separate from that member constituting it. Next, features of company. Company has independent corporate existence. Company is different and members are different. కంపెనీకి సపరేట్ లీగల్ ఎంటిటీ ఉంటుంది. Separate legal entity, limited liability. It can have purchase and sell the ప్రాపర్టీస్, పర్పెచువల్ సక్సెషన్ అంటే కంటిన్యూస్ ఎగ్జిస్టెన్స్ ఆఫ్ బిజినెస్. ఒక కంపెనీ ఇన్కార్పొరేట్ చేసిన తర్వాత అది ఒక ఆర్టిఫిషియల్ పర్సన్, ఇంకా న్యాచురల్ పర్సన్తో సంబంధం లేదు. షేర్ హోల్డర్స్ డిఫరెంట్, కంపెనీ డిఫరెంట్. మనం అట్లా డీమ్ చేసుకోవాలంటే లా అనేది తనకు ఒక ఎన్ఫోర్స్మెంట్ ఇచ్చింది, తనకు ఒక పవర్ ఇచ్చింది. ఇట్ వాజ్ ఆర్టిఫిషియల్ పర్సన్. కంపెనీ తన కామన్ సీల్తో సైన్ చేస్తుంది అన్నట్టు. సో ద ఇండిపెండెంట్ కార్పొరేట్ ఎగ్జిస్టెన్స్ అంటే ఏంటి? ద అవుట్స్టాండింగ్ ఫీచర్స్ ఆఫ్ కంపెనీ ఈజ్ ఇట్స్ ఇండిపెండెంట్ కార్పొరేట్ ఎగ్జిస్టెన్స్. అంటే ద డిస్ట్రిక్ట్ లీగల్ పర్సన్ ఎగ్జిస్టింగ్ ఇండిపెండెంట్ ఫ్రమ్ ఇట్స్ మెంబర్స్ ఆర్ సపరేట్, ద కంపెనీ ఈజ్ సపరేట్. By incorporated under this act, the company is vested with a corporate personality with distinct from its members who compose it. A well-known illustration of this principle is decision is House of Lords Solomon and Company. ఇది ఒక కేసు ఉంది. ఇక్కడ సపరేట్ ఇండిపెండెంట్ కార్పొరేట్ ఎగ్జిస్టెన్స్ అనే దాన్ని బేస్ చేసుకుని కేసు ఉంటుంది. నెక్స్ట్, లిమిటెడ్ లయబిలిటీ. ద ప్రివిలేజ్ ఆఫ్ లిమిటెడ్ లయబిలిటీ ఫర్ ద బిజినెస్ డెట్స్ ఈజ్ వన్ ఆఫ్ ద ప్రిన్సిపల్ అడ్వాంటేజ్ ఆఫ్ డూయింగ్ బిజినెస్. బికాస్ ఎవరైనా బిజినెస్ చేసేటప్పుడు ద లయబిలిటీ వాజ్ లిమిటెడ్ ఉండాలని కోరుకుంటారు. ఇన్ కేస్ ఆఫ్ అన్లిమిటెడ్ ఉంటే దే మే లయబుల్ ఫర్ దర్ ఓన్ పర్సనల్ అసెట్స్ ఆల్సో. సో ఏ ఇన్వెస్టర్ అయినా ఇన్వెస్ట్మెంట్ మీద వచ్చే రిటర్న్స్ లూజ్ అవ్వడానికి ఉంటాడు, కానీ తను పెట్టిన ఇన్వెస్ట్మెంట్ మొత్తాన్ని లాస్ట్లో చూపించుకుంటే ఏ ఇన్వెస్ట్మెంట్ ఇట్ వాజ్ నాట్ రేషనల్ ఇన్వెస్ట్మెంట్, రైట్? Perpetual succession. Next, the corporate from organization. Next, perpetual succession in the sense continuous existence of business. The members may come and go, but the company was continuously existence. In case of death or insolvency of individual members also, the company is in existence only, right? Next, separate property as separate owner. The company may purchase, owning, enjoying the disposing of property over its own name. The company becomes the owner of capital and assets. The shareholders are not several and joint owners of the company. The company is the real person in which all properties is vested and by which controlled and managed by disposed of. Bacha F. Guzdar versus CIT. The property is vested in the companies only. Next, transferability of shares. The company's shares should capable of being easily transferable. And next, after that, the Companies Act 2013 section 44 declares that the shares and debentures or other interest of any member of company shall be movable property transferable in a manner by the articles of the company. Thus, incorporation enables a member to sell his share in the open market and to get back his investment without having to withdraw the money from the company. This provides the liquidation to the investor and stability of the company. So the money can be getted from investment market only. He cannot take directly from the company in case where he was leaving. Right? Transferability of share. By transferring his share, he can obtain some amount of other person who was transferring. From transferring, he will get. He is a transferer. Common seal in the sense what? 2015 Companies Amendment 2015 Act law. Common seal is a seal used by corporate as a symbol of its incorporation and sole and also statutory requirement for a company. As a department from this concept, the Companies Amendments Act 2015 has declared the requirement of having common seal compulsorily. Now it is optional. However, where a company has opted to have a common seal, the same shall be used provided under the Act and articles. After this amendment, in case company does not have a common seal, the authorization shall be made by two directors or by one director or one company secretary, or else whether company has appointed a company secretary, the company secretary and director they both can get. Lifting of corporate will. In case of fraudulent activities they were doing, shareholders, బికాజ్ ఏదైతే ఇక్కడ సపరేట్ లీగల్ ఎంటిటీ అని మాట్లాడామో ఈ షేర్ హోల్డర్స్ ఎవరైతే ఉన్నారో వాళ్ళు ఫ్రాడ్యులెంట్లీ దేవర్ అవాయిడింగ్ ద ట్యాక్సెస్. ఫర్ ఎగ్జాంపుల్ ట్యాక్సెస్ని అవాయిడ్ చేస్తున్నారు. అలాంటి సిచ్యువేషన్లో ఈ కార్పొరేట్ వీల్ అనేది ఎత్తేయచ్చు. కార్పొరేట్ వీల్ ఎత్తేస్తే షేర్ హోల్డర్స్ కంపెనీ అనేది ఒకటి అయిపోతుంది. కార్పొరేట్ వీల్ అంటే ఏంటి, ఒక పరదా అన్నట్టు. ఆ పరదాని ఇక్కడ షేర్ హోల్డర్స్ ఆర్ డిఫరెంట్, షేర్ హోల్డర్స్ని కంపెనీని డిఫరెంట్ చేసి ఒక పరదా అనుకుంటే, ఈ కార్పొరేట్ వీల్ అనేది దాన్ని ఎత్తేస్తారు ఎవరు, కోర్ట్ ఆఫ్ లా ఎత్తేసినప్పుడు ఈ బోత్ పర్సన్స్ ఆర్ సిమిలర్ అయినప్పుడు ఈ షేర్ హోల్డర్స్ అనేది లయబుల్ అవుతారు. ఎందుకంటే వాళ్ళు ఇంటెన్షనల్గా కంపెనీ క్రెడిటర్స్ కావచ్చు, స్టేక్ హోల్డర్స్ అందరినీ డిసీవ్ చేయాలని చూశారు. సో బై అవాయిడింగ్ ద ట్యాక్సెస్ గవర్నమెంట్ని కూడా డిసీవ్ చేయాలని చూశారు. కాబట్టి దే కెన్ రిమూవ్ ద కార్పొరేట్ వీల్, లిఫ్టింగ్ ద కార్పొరేట్ వీల్. ఇక్కడ పారాగ్రాఫ్ వచ్చేసి, the phrase lifting the wheel is looking behind the company as a legal person, that is, disregarding the corporate entity and paying regard instead to the realities behind the legal facet, where the law ignores the company and concerns themselves directly with the members or managers. The corporate will may be said to have been lifted only in the inappropriate circumstances. The court may willing to lift corporate wheel, and that too when questions of control are involved rather than merely a question of ownership. The following are the cases where the company law disregards the principles of corporate personality, or the principle that the company is legal entity distinct and separate from shareholders and members, and the law relating to trading with enemy country, in case the company was trading with enemy country or where the test of control is adopted. Next, in certain matters consider the low law taxes. In certain matters concerning the law of taxes, duties and stamps, particularly where a question of controlling interest is an issue, where companies from other companies as their subsidiaries to act their agent, the application of doctrine may operate in favor of such companies depending upon the facts of particular case. Suppose a company acquires a partnership concern and registers it as company, which becomes a subsidiary of acquiring the company. In an action for compulsory acquisition of business premises of subsidiary, it was held that the permanent company, which was through itself nominee held by the shares, was entitled to compensation. Maintain action for the same. Where the courts find that there is avoidance of welfare legislations, employee welfare legislation activities, it will be free to lift corporate wheel. Workmen association rubber industry versus associated rubber industry ఇది ఒక కేసు. The courts invariably lift the corporate wheel or disregard the corporate personality of the company to protect the public policy and prevent transactions contrary to the public policy. Next, under the law relating to exchange control, the court pierce the corporate wheel in a question of quasi-criminal cases in order to took behind the legal persons and punish the real persons who have violated. Quasi in the sense the law giving the right to lift the corporate wheel, where the use of incorporated company is being made avoid legal obligations. The court may disregard the legal personality of the company and proceed on assumptions as if no companies existed. And in latest judgment, Honorable Supreme Court of India in the case of Estate Officer Union Territory Chandigarh versus Estate Information Technologies Limited 2016 held that lifting of corporate will could be done in case of transfer of shares of company which actually was sale of land which the original allottee company was prohibited to do so. In case of land use also transfer of shares also they can include the matters. And next after that 1.1.13 nature of business of organization. What is the nature? Public sector, joint sector. There are various types of organization doing a business in India, and profits may not be the motive or objective. Where there is a substantial government investment is there. This factor is also called social sector, as it caters the needs of society. We may categorize public sector as follows: the following government ownership. Public sector, the sector companies of the following government departments in railways, ordnance factories, postal services, etc. Statutory corporations set up and run by the government, that is Reserve Bank of India, created by the Reserve Bank of India, and companies of insurance companies, electricity companies. The majority holding of central and state government is having. Next, joint sectors, where government have investment rate between 26 to 50%. May be classified on the basis of incorporation, number of members, size, basis, control, and motive. On the basis of incorporation of companies, it may be classified into charter companies, statutory companies, and registered companies. On the basis of liability, the company is limited by shares, limited by guarantee, and limited companies. Further, the basis number of members, one person company, public company, private company. In case of size, divide into small companies or other companies. On the basis of control, they may be classified into holding company, subsidiary company, and associate company. Right? On the basis of classified into holding, basis of control. And companies may also under other categories like not-for-profit organization, not non-profit companies licensed under Section 8, government companies, foreign companies, doormat company, nidhi company, investment companies, producer companies, etc. Next, promotion of a company. Economic definitions are completed. Next, promotion of a company. How does the promoters get register? Next, class.